Hello, this is Paul Callaghan from Taylor Wessing. Thank you very much for joining our EMIR General Council webinar, where we're going to be discussing what's happening in Europe. The topics that we're going to look at particularly today include an update on Brexit, what's been decided, what hasn't been decided, what do you need to be doing or thinking about doing in terms of how Brexit could potentially impact your business. We're then going to have a review of GDPR. Now that GDPR has been enforced for a couple of months, what do you need to be thinking of practically? Hopefully everything is already in place in relation to your documentation and your basic GDPR compliance, but what's going on in the real world now and what do you need to be thinking about? And then also, because a lot of our particularly US and Canadian headquartered clients have been asking about contractual jurisdiction for commercial contracts, Sian Skelton, one of my partners in that area, is going to discuss in detail some of the issues to be aware of in relation to different European jurisdictions if you get pushback in relation to US law. But to start with, we're going to look at Brexit, and we're going to begin by hearing from Vikki Wiberg, who is a senior counsel in our immigration team, who will explain what the government has already announced and decided in relation to immigration issues. It is one of the areas where we do actually have some concrete information to be able to share. Vikki, over to you.
Thanks, Paul. Good morning, everybody. As Paul has said, I'm going to try and give you an update on where we are with regards to immigration issues for Brexit. And this is a really live issue, not least because the Brexit day is the 29th of March next year, so coming up at us relatively quickly. Many of you on the line are likely to have European national staff based in the UK. Many of our clients have a large number of European staff, so this might well be an issue which is currently something you're already thinking about. I think the first thing that I'd like to say, because I have this conversation quite regularly, is that it's important to remember that Brexit doesn't impact on non-EEA nationals. And when we say EEA, we mean nationals of Europe, but a slightly wider version, so including Norway and Switzerland as well. So the current points-based system that we use for non-European nationals remains unchanged and won't be impacted by Brexit. So that's quite important in case any of your staff members here are asking those questions. The other thing that's really important to remember is that there won't be any change to EEA national or Swiss national or their family members' rights to live and work in the UK until the end of the implementation period, and currently that is the 31st of December 2020. So what that means is during the period from the 29th of March next year until the end of 2020, your staff will need to make some applications under the current proposals, but they're going to still be able to remain and live and work in the UK. So again, that's important if staff are concerned about the immediate impact on them. There are up to 3.5 million EU citizens in the UK, so it's quite a big proportion of our workforce. In some industries, it can be sort of 50% of staff members are European, particularly in hospitality, for example, or construction. We have a lot of European nationals working in the UK. And we are seeing an immediate impact on those European nationals. For example, there's been a 25% decrease in net migration from Europe in the last year, so in 2017. There's been quite a substantial increase, and we're noticing, particularly in some industries such as construction, that's being really felt by them, that they're having difficulties accessing some staff. So, as I said, any European nationals, including their non-EEA family members, so you may have, for example, a French employee who has an American wife, that they will also be protected as long as they're in the UK before the 31st of December 2020. So it might be part of your planning to think about if you want to transfer people across to the UK, then it's worth doing that before the end of 2020 to protect their rights. And the other thing to remember is that our government here is advising European citizens at the moment not to submit any sort of applications to preserve their rights to be in the UK. That's predominantly because there's no impact on European nationals' rights to be here, but also because we're going to have a new system which comes into play at some point in the start of next year. I'm going to explain to you why you might want to not agree with government advice on that point, and why you might want to work with your staff members to make applications already as well. So as Paul mentioned at the outset, excuse me, immigration is one of the few areas where we do have some concrete proposals in relation to Brexit, and those were introduced from the 7th of November last year, and they have been updated a little bit since then, although interestingly not in the most recent round of proposals the government issued to us last week. The proposals that we've seen only relate to those people who are already in the UK or who will arrive by the end of 2020. So what we don't know yet is what will be the case from the start of 2021. And I think that's partly because the government just doesn't want to think that far ahead, to be honest, and will have to come up with some proposals. It may be that our post-Brexit system looks a little bit like our points-based system, for example. We just don't know what that's going to be at the moment. So the proposals that we have say that if you have a European staff member in the UK and they've come into the UK before the end of 2020, they will need to apply for a working status. And they will need to have done that and hold that status by the 1st of July 2021. And there are two types of status. The first one is a settled worker status, and that's an application that someone would make if they've been in the UK for 5 years and they are a qualifying European national, and that means they've been working here or studying here or seeking work or are self-sufficient. So that will probably cover most of your staff members. If they haven't spent 5 years in the UK, then they would apply for a pre-settled worker status, and that is to evidence the fact that they arrived in the UK before the end of 2020. And that's the case even if your staff members already hold permanent residence, which is essentially the application type that staff members can make if they've been in the UK for 5 years already. So if somebody has applied for permanent residence, there will be a system to transfer that document into a settled worker status in that transition period up to the 1st of July 2021. And this is mandatory. So even if your staff members have been in the UK for 10 years, 20 years, 30 years, if they're a European national, they will need to apply for a settled worker status in that time frame. We understand from the government that the system should be online in the first quarter of next year, and it's going to be a digital and streamlined user-friendly system, and the government have assured us that they are going to rely on existing records. So your staff members who are already paying tax here, for example, will have a record of their residence with our tax authorities, the HMRC, and that means that they won't have to provide much documentation with their application. And also, you'll be pleased to hear, the government has assured us that there's going to be no refusal of application for minor mistakes. So if someone makes a small mistake, they should still get their application approved, which is good news because it's not always the case under the current system. So that's a really positive move. We're also assured that the cost will be no more than a passport application, which is currently £72.50. And that's a little bit of an increase from the permanent residence cost, which is £65, but more or less the same. And there are, as I mentioned, the proposal has been out since the start of November last year, so really coming up to a year. There are other proposals that government has issued which might be of interest to those of you on the webinar. There was a very recent government white paper which called for visas for European nationals to be in a position where they can visit the UK for short-term business without applying for a visa, and that would look very much like your ability as a US national to come into the UK for business and be issued a visa on arrival. And I think that's been an interesting proposal. It's not something that I think has been particularly commented on yet, but it would be interesting and helpful if you have staff who are just popping to the UK maybe for a few weeks for meetings. They don't need to apply for a visa after Brexit. But we will see if that proposal is something the government takes forward. Hopefully it will. So turning now to the question of what should your EEA nationals do? If you have staff members who are in the UK and they've already been here for 5 years, they could wait for that new system to go live, the new digital streamlined system to go live from Q1 next year. And that's something that a lot of people are doing. They will then have a couple of years to make their applications, so that might be something that staff want to do. However, if you have staff who are concerned about what Brexit will look like, and some people are, they want reassurance, maybe they have family members, they have children who are studying here, then if they've been here for 5 years already, you might want to consider working with them to apply for permanent residence now. And that's particularly the case if those staff members are interested in becoming British citizens moving forward, because it's something that they would be able to progress quickly. The application is really simple. We're finding at the moment that applications take between 1 to 2 months to process, and particularly if the person applying has worked in the UK for 5 years, their application form is fairly straightforward and the documentation required is very simple. We are mindful, as you'll see on the slide, that the system is going to have to cope with an awful lot of applications when it's introduced. And if you remember, I mentioned that we have about 3.5 million European nationals in the UK, and we've worked out that looks like something along the lines of 15 applications every minute to be approved for processing 3 million applications for European nationals for settled worker status or pre-settled status, which our IT systems may find difficult to deal with. So, making an application now, there's merit of doing so because we know that the system works pretty quickly and it's pretty cheap, and that gives staff reassurance, and you might want to get ahead of the curve in doing so. We don't know how family members are going to be treated after Brexit. We know now that if your staff members have non-European national family members, they can come into the UK under European rules, and that's really helpful and very reassuring. We don't know if that's going to be the case after Brexit because UK nationals can't always bring non-UK family members into the UK. So that's something to think about. If you have staff who are particularly concerned about maybe their non-European parents, you might again want to look at getting an application submitted for them now. And the other point I wanted to make here is that the government's proposals all assume that we have a Brexit agreement in place by the end of March next year. What we don't know yet is what the government would propose if there's a cliff edge Brexit. And again, that might be a reason to work with your staff to make an application in advance. So thinking about that, you might want to consider what practical issues you can think about. How can you support your own European national staff? You might want to offer them legal support. For example, you might want to offer to pay for their visa fees. So it's only £65 to get permanent residence. You might want to circulate Q&A documents, for example. That's something that we're doing with a lot of our clients. Or have a presentation for staff to help them understand how to make their applications, all quite cost-effective ways of supporting your staff. I think it's really important that you are thinking about what the future restrictions might be. We understand that for low-skilled workers, there may be time-limited visas, and for high-skilled workers, if we're looking to the non-European points-based system, as many of you will know, a lot of intra-company transfer visas are limited to 5 years, and it may be that that's the case going forward. So again, you might want to work with your colleagues across Europe and consider whether to move people across to the UK before the end of 2020 so that they can benefit from that European right to live and work in the UK now, even if they only just come before the end of that sort of implementation period. So that's something to consider. I would also say that you might want to consider, if you're working on any particular projects in the UK, what the impact on costing might be within those, and make sure that you're speaking to your advisors about how to give yourself flexibility in your contracts. For example, if you are buying a company which is very reliant on European staff, you might want to think about how to manage that to ensure that your costs are going to be maintained if you're more reliant on UK staff or visas going forward. So that's something to think about now and to start building in, and we're already seeing that clients are doing that with contracts that are forward-facing at the moment. So quite a few practical issues that you can consider now. And we've had a question actually from Jessica about trusted traveller status. And Jessica, that's a great question. The trusted traveller status, which is also the registered traveller scheme, is only applicable to certain non-EEA nationals, so that won't be affected by Brexit. It may be that it's expanded to cover European nationals, but that scheme will still be in place as far as we know following Brexit. And I know if your staff aren't registered travellers, it's definitely a scheme worth looking into. It means that you're going to spend a lot less time in our passport queues going forward. So I'll pass on to Paul. Hopefully that's been a helpful sort of guide as to some of the things that you might want to think about. And Paul's going to talk about employment matters now.
Yeah, thanks, Vikki. And although there's quite a lot to say on immigration, the reality is that there isn't that much that we know for certain in other areas. In some ways, that's a good thing, and in some ways, it can be unnerving because no one likes uncertainty. What generally seems to be quite clear is that the UK will either do some sort of deal with the EU before we leave the EU, whereby we effectively agree to keep all of the EU rules and regulations in place for a specific time, or if we leave the EU at the end of March next year without a deal, then we won't be committed to that, and it's quite possible that the UK will start to deregulate in some of those areas that business finds particularly annoying, and the UK, which is already known for being the most business-friendly and flexible place to operate in the EU, will become even more so, but we shall see. Now, in the area of employment law, what the government has said so far is that there are no plans to change employment laws. As you probably know, if you're dealing with a number of European countries, although the UK's employment laws can sometimes initially seem quite alien and different compared to what you might be used to if you're generally dealing with US-based employees or Canadian-based employees, they are the most flexible in the whole of Europe, and that's likely to remain the same. There's certainly no proposal to regulate more in the employment sphere, and if anything, I would have thought we would see some deregulation after Brexit in relation to employment law issues. But as I say, the paper that the government brought out recently essentially says no change. The one area where there may well be some change is in relation to European Works Councils. If you're a large company and you have a significant number of employees in different European countries, it may well be that you already have to have a European Works Council. Now, because the UK is going to be outside of the EU, the UK government have accepted that means that the UK will no longer be subject to the EU Works Council Directive rules, even if we're agreeing to comply with the rules in every other respect should a deal be reached with the EU. So what that means in practice now is if you happen to have a European Works Council and it's subject to English law, because essentially it needs to be subject to the laws of one of the EU countries, and that will need to be changed. And some companies are moving from the UK, which has always been generally considered the easiest jurisdiction under which to have a European Works Council, to Ireland, which is considered to be the second best in terms of that particular legislation. So that's something for you to think about. On the other hand, the very good news is that if most of your European business is in the UK, or if you're going to make most of your European business in the UK, you may in fact no longer have the number of EU employees anymore. That would mean that you have to have a European Works Council. So if that was something that you didn't want to continue with, or you didn't want to risk having to put into place, then if you are very UK heavy in terms of your employee numbers, then that is one bit of very good news already. Just looking generally at the impact on the rest of the EU of Brexit, and again, as Vikki's been saying and I've been saying, not knowing for sure is the real disadvantage of the Brexit process. But if we do reach an agreement with the EU before the end of March, as I've already mentioned, there is this transitional agreement that is in place, which will mean that nothing at all will change until December 2019. So in a way that makes everything easy, no change. Although, of course, we haven't got that agreement yet to trigger the transitional agreement, so it's perfectly possible that the UK will simply leave the EU and then will be free to deregulate and potentially make itself even more business friendly. And so what will that mean for the rest of Europe? And if you are thinking about where in Europe you should be, either in addition to or potentially even instead of the UK, what sort of things should you have in your mind? Now, historically, Ireland has often proved to be a very popular choice, particularly for North American tech companies, to have their EMEA headquarters. And the reason for that has been primarily because they have a low corporation tax. Corporation tax in Ireland is lower than corporation tax in any of the other EU countries. However, the French and the Germans and most of the other EU countries have objected to that, and they've been putting pressure on the Irish to increase their rate of corporation tax. And that's because they feel that Ireland gets an unfair advantage. And in recent years, we've seen it's become even more important in order to get that Irish corporation tax that you're able to demonstrate that you do have your key European decision makers based in Ireland. And that's sometimes a challenge because Ireland is a country with a very small population and therefore not a large talent pool. So to have your key European employees in Ireland is not always easy. And people often compare Ireland, or at least I've heard it compared to Alabama in terms of population size. The population of Ireland is just a little bit lower than the state of Alabama, albeit Ireland is a lot more regulated than Alabama, even if it's equally rural. So whether Irish corporation tax will remain at that low rate remains to be seen. And we've also got the challenge in Ireland of their highly regulated employment laws. In the UK, if you're used to dealing with employees, you will know that there are certain processes you need to go through to avoid unfair dismissal claims for employees who have 2 years service or more. In Ireland, those rules kick in after just 1 year, but more fundamentally, more important, and what we have certainly seen with clients who have employees in Ireland, is that if you don't follow the right processes before you terminate someone, then that individual could potentially get an injunction and stop you from firing them or even get themselves reinstated. So there's a bit of a wake-up call that we're seeing with some tech clients doing business in Ireland that you just need to think about. A potentially easier alternative to the UK or Ireland or an addition to is Germany. Now, Berlin in particular is known as an increasingly important tech hub, although as it happens, the gap between London and Berlin has, as I understand it, widened, even in recent times after the Brexit vote, with more and more tech money coming into London. But still, Berlin is a good alternative and a good additional option. And the good news from the employment law side is that if you have fewer than 10 employees in Germany, then in fact you've got something close to at-will employment. Over 10 is a very different story, where it's very hard to terminate for poor performance, and you run the risks of having works councils. But if you're thinking of a small-scale operation, then Germany and Berlin is definitely somewhere you need to think about. Looking very briefly at France, now France often rings alarm bells, particularly with North Americans who've had very unfortunate experiences of trying to deal with French employment laws. Saying that, President Macron has liberalised French employment law, so it's not quite as employee-friendly as it used to be, but clearly some of the historical concerns about doing business in France will still apply. The Netherlands is often a very good place to do business. Again, there are tax structures that are very beneficial there, and if you have employees on short-term contracts, it can be quite straightforward to do business. The one thing you really need to be aware of with the Netherlands is that anyone on a regular, ongoing contract of employment can't have their employment terminated unless you actually get a court order, and that, which certainly to North Americans and to the British people seems astonishing. So all of these European countries have different rules, and they're all a lot more onerous than the UK, but each have pros and cons. So Brexit doesn't necessarily mean that the ongoing EU countries will have smaller scale investment from North America. It doesn't necessarily mean that everyone will be coming to the UK. But obviously, if the UK does deregulate and become even more business friendly, then those are the sort of issues that people are going to be taking into consideration. So that's more or less where we are with Brexit. And I just want to turn now to GDPR. Certainly, in the first half of this year, every business that carries out any business with Europe has had to comply with these GDPR rules. And everybody, more or less everybody now, seems to know that if you don't comply with GDPR, you risk fines of up to 4% of global revenue, which is a very frightening figure. As well as the fact that even if you don't do business yourself in Europe, if you're contracting with somebody who does, they might be trying to flow down their GDPR obligations to you. So our data privacy team has been super busy, and I know most of our clients have been extremely busy trying to sort everything out and make sure that they're GDPR ready. And that, of course, is not just about the customer data, it's also about the employee data. And I just want to chat through with Roxane Davey, one of our senior associates in the employment team, where we are with GDPR, particularly on the employee side, because a lot has been happening, and it would be useful just to talk through some of the issues that businesses now need to be aware of, now that GDPR has been in place for a few months. So, Roxane, do you think, in your experience, are most companies ready and compliant in relation to employee data when it comes to GDPR?
Hi everyone. Some are, but lots aren't. So many are still getting to grips with the extent of the change that the GDPR demands, and they're working towards compliance, but I wouldn't say that they're quite compliant yet. Lots have got the key documents in place, such as an employee privacy policy or notice, but many still have work to do in ensuring that GDPR principles are complied with throughout the employment relationship. So starting right from ensuring candidate data at the recruitment stage, all the way through the employment relationship to disciplinary grievances and monitoring and so on. And what's important to note is it's not just the written policies that you've got in place to demonstrate that you're attempting to be compliant with GDPR, but it's important that your actual practices that your employees are being asked to comply with and your HR teams are complying with are also consistent and compliant. So it's a bit of a wider training piece and making sure that people have this in the back of their minds day to day and not just when it comes to implementing policies.
Thanks. And what I've really noticed over the last few months is the different, often conflicting advice that our clients have received. Often when they've been using consultants, whether it's data privacy consultants or HR consultants, we've seen a real range of advice, some of which, from our perspective, is clearly wrong. And what would you say about that, Roxane?
Yeah, so one of the things that we've seen is that lots of precedents that seem to be out there are still largely relying on employee consent. So this is odd because one of the key changes under the GDPR in the employment context is that consent is no longer capable of being relied upon. So this is because under the GDPR, consent needs to be freely given. And due to the perceived imbalance of power in the employment context, it's widely felt that it can't be freely given from employee to employer. So consent should really be the last resort, and rather than relying on consent, employers should be able to justify the processing for other reasons. But many of the documents that we've seen don't reflect this, and many just seem to refer to consent at the outset, rather than exploring these other reasons.
So they're basically wrong, and
they are.
Employers vulnerable.
Yeah, absolutely. It gives the impression that employers are only relying on consent when everything that they're doing in the background is probably the opposite to that, but unfortunately these documents don't reflect it.
Yeah, so I guess our advice is if we haven't been involved in your GDPR advice, do check that your changes to employee contracts and any privacy notices that you've been giving to employees, as well as your new employee privacy policy, do make sure that they are actually explaining why you're processing employee data and not trying to get employee consent. Because if there is an employee consent provision in there, you're really laying yourselves vulnerable to complaints and to fines, I would say.
Yeah, it just gives the wrong impression as to what you're doing.
Yeah. Okay. And another thing that is a part of GDPR and that we had to some degree before GDPR are subject access requests. Do you want to explain, Roxane, what exactly a subject access request is and what you're seeing now in a GDPR world?
So a subject access request is a request usually made by an employee to an employer, in which the employee asks the employer for copies of all of the information, all of the personal data that the employer has on the employee. We've seen them for a long time, and I wouldn't necessarily say we've seen a big rise in them since the introduction of the GDPR. They're a tool that are commonly used by disgruntled employees. They're often brought up when there's already a dispute between employee and employer, often when the employee is still employed, but sometimes afterwards when the complaint might have got to the tribunal stage or just before that. And employees are using this as a kind of pre-action disclosure mechanism. Because they genuinely want to see what data employers have on them, and B, also because they realise that it can be a fairly onerous task and it puts the employer under pressure in dealing with it. The key changes that we've seen under the GDPR from a practical perspective are that you can no longer charge the £10 fee to employees, and that used to often be a common tactic employed with employees to try and delay the start of the clock ticking for responding to the request. And also the reduced time frame for compliance. It used to be 40 days, so that's now been reduced to a month, so employers have a bit less time now to comply. As always, with subject access requests, we recommend that employers employ a systematic approach in dealing with them. So think about what data is in scope, think about where it is, think about whether any exemptions apply and whether any information needs to be redacted.
Okay. And if employees are unhappy with the response to the subject access request, then they need to complain to the Information Commissioner's Office. And presumably they are now very well staffed and dealing with a lot of complaints following GDPR. But what have you seen about their approach in general?
In our experience, we've seen them take quite a pragmatic approach. So when I've dealt with them in the past, they've generally begun when they receive a complaint from a disgruntled employee by asking the employer what they've done to comply with the request, and essentially giving the employer the opportunity to state their case and defend their position. They have asked some quite detailed questions, and so employers need to be ready for that. But if the ICO agrees that the steps that the employer has taken are reasonable, then we have seen them determine that no further action is required. We've seen a 50% increase in ICO complaints since the implementation of the GDPR, but in my experience, the ICO has been relatively quick at dealing with them. A few years ago, when an employee made a complaint to the ICO, it would often be quite a long time before the ICO actioned it, but I've seen them taking up these complaints faster. In order to get to the stage where the ICO is agreeing that the steps that the employer has taken are reasonable and that no further action is required, the employer needs to have dealt with the request reasonably, and they need to be able to evidence this to the ICO. So we always suggest that employers are keeping a paper trail of the decisions that they've made when complying with the request, and any exemptions they've relied on together with the rationale for that.
Okay. That's really interesting to hear. Another area where GDPR is potentially really important in the employment context is with potential whistleblowing. And I've certainly already noticed a number of employees making complaints that they're not satisfied that GDPR compliance is being carried out properly in their company and potentially whistleblowing about that. What do you think that a company should be doing to make sure that it's not vulnerable in that respect?
So the first point to note is that compensation for a whistleblowing claim, if successful, is uncapped. This makes it a really attractive claim for employees to try and bring. And so that's one of the reasons why they're on the increase. So by way of a reminder, the test to be met in a whistleblowing claim is twofold. The first point is whether or not the employee's made a qualifying disclosure. And there are 4 points to note here. So the first is whether or not they've made a disclosure of information. Now, merely gathering evidence or threatening to make a disclosure isn't sufficient. The employee actually needs to say that they think something has gone wrong and make that disclosure. The second point is the subject matter of the disclosure. Under statute, there are 6 types of relevant failure that an employee can be making a disclosure about. Now, in this type of data privacy issue, this is likely to be breach of legal obligation, i.e. because they consider the employer breached its obligations under the GDPR. Thirdly, the worker needs to have a reasonable belief that the information tends to show one of these relevant failures, and it's quite easy to see how in a data privacy case an employee can show that they've got a reasonable belief that the employer has not complied with its legal obligation. And finally, it needs to be in the public interest. But even though this sounds like a relatively high threshold, it's possible for workers to still show that complaint is in the public interest, even if it just applies to a wider group of employees or client data. The final hurdle that they need to overcome is whether or not it's a protected disclosure. So that means it needs to be made usually to the worker's employer, but sometimes also it can be covered if it's made to third parties. So if we look at all of these points that they need to satisfy in order to receive whistleblower status, it's easy to see that employees raising data protection concerns, which affect the wider workforce or the client base, could demonstrate that they've blown the whistle for the purposes of this whistleblower protection. So what we suggest is that if you have employees that have raised these concerns in the past, and then something comes up and there's cause to discipline them or potentially dismiss them, it's really important that you ensure that the reasons for these subsequent actions can clearly be explained and removed from the employee's previous disclosures about data privacy. It's really important that the two are separated to try and limit the chances of the employee successfully being able to link disciplinary action or dismissal to any disclosure they might have made in the past about data privacy.
Okay, so that's something where really it should be a red flag issue for anyone in your HR team if someone is complaining about GDPR, especially if it might be an employee where you have other issues on performance concerns and where you may get a sense that they're looking for a way to protect themselves and have a go at the company in some sort of way. So just be careful not to completely disregard it and take advice to make sure that you are on safe ground. So another area where GDPR is relevant in the employment context is in relation to workplace investigations. Roxane, what have you seen there and what sort of advice are we giving to clients about changes they should make in relation to workplace investigations?
So as you mentioned earlier, it's important to note that the reach of the GDPR comes into play even for businesses that are established outside of Europe. So specifically in the context of investigation, companies with operations in Europe need to comply with the GDPR if EU data is to be reviewed as part of that investigation, even if the data being reviewed is stored outside of the EU and the team running the investigation is outside of the EU. So always the GDPR basic principles need to be followed when processing personal data, and that also applies in the context of investigations. It applies from the very outset when the initial data is being sought, and then all the way through when the data is being reviewed, when it's being transferred, and whether that transfer is within a group of companies or to third parties, such as authorities or forensic analysis providers and so on. So the processing needs to take place in a transparent way. So this means providing specific notice to employees to let them know that their data might be processed in connection with an investigation. We also suggest that the data that's reviewed as part of the investigation needs to be limited so that only the data being reviewed is the data that is really needed to properly investigate the issue. So we recommend that at the outset any data is filtered to ensure that it's only the relevant data that is actually being looked at. Another key point is that the data should be used beyond the purpose for which it was collected. So, for example, if data is collected for the purpose of an investigation, it should be limited to the team carrying out the investigation. And transfers of the personal data outside of the EU, for example, to a North American parent company who might be running the investigation, also needs to satisfy specific conditions. So think about whether or not you've got any intercompany agreements in place that govern the transfer of this data, whether the US entity is operating Privacy Shield with regard to HR data and so on, and whether these are things that you can rely on. Specifically, another step to take is also to review any internal investigation guidelines and policies that you might have in place to reflect the GDPR, to make sure that these points are covered off in them, and ensure that any third party with an interest in the investigation is made aware from the outset that GDPR will obviously have an impact on the investigation, so that they're aware of the limitations that that might impose.
Okay, thanks. Well, I hope you found that helpful, looking at where we are with GDPR right now. Another very different topic that we want to introduce, because it's something that seems to be coming up with North American-based clients a lot, is talking about commercial contracts and which European jurisdiction you should make those commercial contracts subject to. That's assuming, of course, that whoever you're contracting with won't accept the US jurisdiction that you might want. And Sian Skelton from our commercial tech team, who has spent a lot of time working with clients in this space, is going to talk through some of the issues to be aware of.
Thank you, Paul, and good morning. So why are we talking about governing law and commercial contracts? And this is predominantly because anecdotally our clients are saying that when they are negotiating with their clients, mostly on continental Europe, that they are facing pushback from the preferred position that most North American clients take of having English law and English courts govern the applicable law and jurisdiction of the contract that they are entering into. And this is predominantly coming up because of Brexit, or this is what we're being told by our clients. And so I thought it would be useful to this morning to be able to discuss a little bit about English law, why we still consider it to be a good basis for contracting on, and possibly some alternatives if you are pushed to that commercial position. Okay, when we're talking about these contracts, we're talking about B2B contracts. B2C contracts will be, as they are currently, governed by the local law of the consumer, and therefore it's very important when we're talking about governing law and jurisdiction to bear in mind that we're talking about business-to-business contracts, where each party is free to choose and decide which is the law that will govern and which is the courts that will decide any disputes that arise out of the contract. On the whole, parties are free to decide those governing law and jurisdiction. However, if you are in a regulated industry, there may be some exceptions to this, and therefore it's always best to know the position of the business that you're operating in and the legal landscape that you're operating in before entering into any specific contracts. So if we take a step back, I think it's important to think about why many North American clients will choose to have English law and courts in their commercial contracts. And English law has been attractive to businesses entering into contracts. It's like the US. English law is based on a common law system. It is internationally viewed as a very or a relatively stable and predictable court system, and it's with a number of and case law which will help the courts and provide predictability in terms of the outcome of any legislation. Of course, if you're going through a court process, as we all know, there is no such thing as a guaranteed or a certain outcome, but certainly it is felt internationally that the English courts can provide more predictability than, say, some of the other court systems, especially across Europe. If we turn to the legal systems across Europe, there are other common law jurisdictions, particularly in Ireland is one to note, but many of the other European jurisdictions are based on a civil law codified system, which is very different to the North American system and therefore requires more specific legal advice in terms of the contract that's being entered into. Additionally, it's also worth noting that where you're on continental Europe and you're dealing with a contract that most companies in continental Europe will look to negotiate and draft their contracts in their native language, which again places those of us who speak English or from the UK or from the US in a disadvantage in respect of negotiating and concluding that contract in a timely and cost-efficient manner. So, interestingly, where you've already got contracts that are under English law and where they are due to run past the date of Brexit, which is the 29th of March 2019, we are starting to see some clients receiving requests from customers to change the governing law. I think in this instance those requests should be really looked at and sort of completely understood as to why that request is being made. It is an unusual request unless there's a commercial requirement to do so or potentially a regulatory requirement to do so, and it should be, in our view, resisted as far as possible. There are EU provisions which will remain post-Brexit within those countries that remain within the European Union that require the European courts to recognise non-EU member states' laws. So where you have a contract that's governed by English law and you're trying to enforce it on the continent, that contract should remain enforceable across the whole of Europe, and that there should be no change to the current position that you have. Again, highly unusual to change governing law only, but we are seeing some requests to do this. And anecdotally, we're hearing that clients are being asked to do this predominantly because of Brexit and their customers' nervousness about English law governing their contracts. I suppose more pertinent to contract negotiations that are happening at the moment is the governing law that you choose at the moment. As I said earlier, even after Brexit, there should be no change in approach. Our advice is that English law, English courts will continue to have the same predictability, the same certainty. We'll have the same body of case law that will apply to all that the courts will apply. And while we are still working through the actual outputs and consequences of what Brexit will actually mean within the legal system, the commentators and the government have been very clear that we're not expecting any major changes to our legal system, or indeed the approach that we take as a country in respect of dealing with contracts and contractual disputes. And therefore, you should still can take certainty and comfort from the fact that English law is the right way to start. Even if that's the case, anecdotally we are hearing from clients the following types of claims being made. So, we're hearing from clients that, the pushback that they're getting from customers are that, English law won't be enforceable after Brexit. Once the UK leaves Europe, the courts won't recognise English law. As the UK is no longer part of the EU, we no longer accept English law as governing law. Obviously, these are not legal arguments. These are, another a string in the bow of a commercial negotiation. As I said at the top of this piece, in business-to-business contracts, the parties are free to choose governing law and jurisdiction. And historically, it's always been a commercial negotiation as to what governing law and jurisdiction should apply within the contract. So the use of Brexit may just be, in this way, with this sort of commentary, may just be a way of your customers trying to push their own agenda to get a governing law that they're more comfortable with, or a jurisdiction that they are indeed more comfortable with. For instance, because it's the jurisdiction and governing law of the country in which the customer is based. So I still think, and we're still advising clients that they should continue to push back and to continue to apply English law on that basis. However, if this commercial discussion and commercial negotiation doesn't work, then there are other things to consider when negotiating and concluding which governing law and jurisdiction should apply. A couple of things, and it's the same as it is at the moment. It doesn't, the Brexit doesn't apply specifically to this. It will be looking at where the parties are based. Now, if you have a party that's based in a territory that you are comfortable operating in because, let's say, you have a large operation there already, or because you have experience of working within that jurisdiction, or because you are comfortable with the legal system within that jurisdiction, you may well be comfortable with accepting alternative jurisdiction. And this may be particularly the case where the legal system that your customer is based in or proposing is a common law based system. If it's based on a civil code or a codified system, you may want to consider taking specific legal advice on the consequences of that jurisdiction and governing law. If you're not comfortable with the jurisdiction of the customer or the one that's being proposed by the customer, then it's worth considering a neutral jurisdiction. So this could be a jurisdiction that neither party has operations in or is particularly active in, but that each party would be comfortable hearing any dispute within. Examples of countries which we've seen clients turn to in this sort of situation where they haven't been able to agree English law, but they're not comfortable with applying the local jurisdiction and governing law of the customer, have included countries such as Ireland, Holland and Switzerland. The advantages of each of those three countries are that they speak good English, that they have clear legal system and approach to legal basis, that they are relatively similar to English law, and thereby similar to the US approach in terms of their disputes and how they would handle it within the court basis. However, those are just a small number of options. There are others that could be considered. And indeed, if you were unable to agree on a European jurisdiction, then you might consider pushing back quite strongly and going back to using US law. But I imagine if you are operating in Europe, that will be a much harder commercial discussion and negotiation to have with your customers. Where you are considering changing the governing law of any contract, especially where it has been amended and made specifically applicable for a specific jurisdiction, so where you already have gone through the process of amending your contract so that they are working under English law, our advice is always, if you have to change the governing law, that you should take specific advice in the jurisdiction into which you are changing that law as to the consequences of operating and having a contract under that new governing law. Obviously, it's easy to change the words, but the legal effects of changing those words needs to be understood and considered properly by the company itself. So, in summary, our advice remains that English law and jurisdiction remains a good choice, notwithstanding Brexit and the pushback that clients seem to be getting from customers. I think this will settle down, especially as the Brexit starts to become clearer and people get more comfortable with what the consequences for both Europe, those remaining within Europe and the UK will be. But it's just another negotiation tactic for customers and therefore needs to be dealt with appropriately. It's also worth discussing this with your sales team and the people on the front now in negotiating these contracts. They don't need to bend to the whim of the customer unless commercially you are really forced down that road. I hope that's been helpful, but please let me know if you've got any questions.
Thank you, Sian. And we're running out of time, but I just wanted to flag an overarching issue, which is not necessarily specifically about new legal changes, but which is more about a change in mood in the UK. And that's about the importance of protecting your brand and enhancing your brand in relation to a number of compliance issues. Now, we've already talked about GDPR, But Me Too, which has also crossed the Atlantic from North America to the UK, to some degree continental Europe. And if you don't already have in place European compliant sexual harassment and investigation policies, that's something to think about, because you would be very vulnerable if allegations were made and weren't taken seriously and looked into, not just in terms of potential financial costs of employment litigation, but also in terms of damage to your brand in an era in which social media is able to spread messages very, very, very quickly. Similarly, gender pay, another subject that we're not really covering in any detail in this webinar, but if you are subject to the gender pay regulations, which is essentially any company with 250 or more employees in the UK, demonstrating that you're taking steps to reduce any gender pay gap is really important in terms of brand, again, possibly brand even more than legal liability. And likewise, modern slavery. Again, it's only for larger companies. You need to have revenue of £36 million or more as a business, doing business in the UK. But if that does apply to you, and you have to therefore annually display on your website a Modern Slavery Act statement, it is really important to get those right and to make sure that the company is seen to be a good company, a good corporate body, and a good employer to help your reputation in the marketplace. And we just wanted to leave you with those thoughts. We have had some questions come in, and we only have 2 or 3 minutes, but the first one is for Roxane on GDPR. Someone has asked about they've seen an increase in what they describe as trivial complaints about GDPR compliance and whether they should be treated as whistleblowing. Roxane, what would you say to that?
Yes, potentially. If they tend to show that the employee has a reasonable belief that it's a breach of a legal obligation, then they probably would. The actual question said if they're trivial questions. Now, if it's a question, it wouldn't, because that's not a disclosure. But if that leads to them making a disclosure, because, for example, they say, what are you doing in regards to X with my data? You give them the answer and they say, I don't think that's GDPR compliant, then yes, potentially, because that becomes a disclosure. But the final hurdle that they'll always need to overcome is whether or not it's in the public interest. And that would always need to be assessed on a case-by-case basis. But ultimately, even if the disclosure does look like it's a fairly trivial one, potentially they can still be a whistleblower.
Great, thanks, Roxane. And Vikki, the question potentially in your area: if you have expat employees who are currently employed by a UK subsidiary, but are working in continental Europe, should you be looking to set up a new European subsidiary for those employees?
No, I would always say in that situation, do take advice as to what the obligations might be. For example, from an immigration perspective, that person might not have the right to work in that country. And then maybe tax implications and obviously corporate cost implications if you were to set up a subsidiary. So in that case, it does happen quite a lot. Do take advice, because the position will probably depend very much on your circumstances, but generally we would say don't set up a subsidiary.
Great, thanks. And so we are running out of time, but all of the slides will be emailed to everyone who's registered for this webinar, and they contain the contact details for all of the speakers, so do feel free to contact any speaker directly in relation to any questions that you might have. We've also attached a flyer for a service that we're starting to roll out increasingly for larger clients, where we basically try and offer an overall retainer for North American clients, their global legal needs outside of the Americas. And if you're in a company that might be interested in that, having a one-stop shop for all of your non-US or Canadian legal needs, then again, do get in touch, and we'd be very happy to speak to you. I hope you found this helpful. Do tune in for the next EMEA General Counsel webinar, which will be in several months' time, discussing whatever happens to be topical then. In the meantime, I hope you have a good rest of your day. Thank you.